Hi, I'm Claudia Brown Coulter with Pivotal Peace. I'm your go-to mediator for navigating divorce while parenting children with special needs. I'm also a legal document assistant LDA based in the greater Los Angeles area. Today we are talking about responding to a divorce petition. So, in California, the person who files for divorce is called the petitioner, and they file a petition. It's a request. And the person who files the response, or the other person who's not the petitioner, is the respondent. That's the other person. And they file a response. It's an answer to the petition. It's your opportunity to make your own request. It's absolutely possible, if you're having an amicable divorce, that you don't need to file a response because you're going to proceed with a default with an agreement. You guys are working out the terms of your agreement. However, filing for a response does protect your legal rights. It gives you standing in the court. Should things fall apart and you need a judge to rule on something, you can appear before the judge. So let's talk about how to do this correctly. In California, and most states have a deadline. Actually, every state has a deadline, whether that be 20 days, 30 days, 45 days. In California, you have 30 days to file a response. 30 days from when you get served with the petition to file your response. Yes, there will be a filing fee involved with that, but it might be a small price to pay, even though it's not small, but it technically is a small price to pay if you need to go to court and be able to present your side of things to the judge. You want to make sure you adhere to that 30-day timeline. Now, many times judges can be lenient, but why test it? Why ask them for grace for an extension? Just get it done on time. Probably wasn't a surprise. I mean, like, you weren't happy yesterday and getting served with divorce papers today. I mean, like, happy in your marriage. So even if the divorce papers seem to come out of the blue, I mean, you know that your marriage is on the rocks. So especially if you're not living together. Okay, so don't be too surprised. Be ready to file a response. And that's 30 days is plenty of time to kind of get your ducks in a row. Look at the petition, read it, and see what your spouse is asking for. What are they asking for? Do you agree with it? Is there anything that you disagree with? You want to make sure that when you write your response, you actually are noting, I want this. A response and a petition is just asking the court for something. It doesn't mean the court's going to give it. It's just a request. It's your way to formally make a request and have standing. Sometimes, you really want to pay attention to, especially to the area where it has to deal with child custody. Are they asking for sole legal custody, sole physical custody? Do you disagree with that? That's something you should note on your response and request joint legal custody, joint physical custody, something to that effect. Or maybe you're going to need child support and you need it now. You can document those things in your response. Really consider that. A lot of times when people are working together amicably, they don't list out all of their assets and debts on their petition or on their response because they know they're going to do that in step 2 and they're working together towards an agreement. But if you're not sure, you can fill out the FL 160 and really document and have everything clearly defined. You are welcome to do that. You can absolutely do that and just have everything listed there. And that really comes into play when you're thinking about your community and separate property. Remember, community property is property acquired during the marriage. And separate property is property acquired outside of the marriage, unless it's like a gift or an inheritance that comes while you're married. Don't commingle that stuff. California looks at the date of separation as the date that community property stops. It doesn't have to be the actual date of legal separation. It can be the date where the marriage was irretrievably broken, whether someone moved out or that's the date that your spouse filed. that date is important. So when you're looking at the forms, look at that date. Sometimes people disagree about that date. And the reason why that date is important is because that date has everything to do with how much more do you have to pay them, in terms of like, how much more debt do we have, or how much retirement was built up. Are you saying that we've been, our marriage has been broken for a year, but it's really only a month, so I don't get this extra retirement that you've built up? You really need to look at that date. You can come to mediation and reach an agreement on what date you should use and what date things can be valued on, but look at that date and make sure that date is an accurate date of the marriage broke down on this date. Now, if you don't know the date, and if the petitioner doesn't know the date, then it's probably the date they filled out the paperwork. So pay attention to that date, because you want to be thinking about yourself and the protections for you regarding that date. It's a very, very important date. And if you aren't sure about that, that's when you should take the petition and have a consultation with an attorney. Hand over the petition, tell them your concerns, get their advice on how to file a response. You don't have to retain them. You can get some legal advice. Get some advice on how do you approach this? What should we value things at? Like, really have the conversation. Come with the list of all of the things that are keeping you up at night that you're worried about, that an attorney can answer, and use that time wisely. Just because you are filing a response does not mean it needs to be a contentious divorce. It just means you're having an answer. It means that you are hedging your bets in case you have to stand in front of the court. Keep an open mind, though. Be open to negotiations. Be open to having conversations. Be open to settling out of court. That will make your life easier. Once you filed your response, you will also get a copy of the filed response back from the court. You'll need to serve your spouse too, to let them know that you're filing a response. Keep a copy of your response. Keep a copy of all the filed paperwork. Keep a copy of the papers that you were served with. Keep them in a central location. If you don't like paper, scan it and keep it in a central folder on your computer. Don't lose this. Sometimes people take way too long to finish their divorce because life gets in the way. And then when it's time to pick back up, they don't know where they're at because they don't have their paperwork. They don't know what's happening. They don't even know their case number. Keep your documents and keep them together. It will make it easier. So this doesn't have to be a complicated process. This is something I can help you with. I cannot give you legal advice, but I can help you fill out these forms according to your direct instruction so that you can get this process taken care of. We'll get it filed with the court for you, and you can keep the divorce moving along. Remember, just because you need to file for a divorce does not mean it needs to be contentious. You can still have an amicable divorce, but you are going from an entity, a unit, into two. So you need to protect yourself and get the legal advice you need so you can protect yourself going forward.